Very much. Senator Coons?
Thank you, Chairman Durbin, and thank you to our witnesses today and to this committee for paying so much attention to the urgent issue of voting and the rights of Americans to vote. It is so profoundly disappointing to me that in 2021, following our last election, we need to have a hearing to address a surge in voter suppression efforts around the country. In a healthy democracy, the side that loses an election then takes time to reflect on why and how and what the issues were that might have moved voters to their side. We instead see in legislatures across the country efforts to suppress the access to the ballot box, the opportunity to vote. Bills like the one that passed in Georgia, I view as an affront to the legacy of John Lewis and others who risked or spilled their own blood to win the right to vote. As Ms. Eiffel knows well, I've long worked to support my colleagues' efforts, Senator Leahy's efforts and others to pass the Voting Rights Advancement Act, now renamed the John Lewis Voting Rights Advancement Act, and I want to ask some questions about that today and about our efforts to try and plug the hole created by the Supreme Court's ill-conceived, I think, decision in Shelby County in 2013. Ms. Eiffel, if I might just start with you. As a matter of common sense, I think we all have a pretty clear idea of why some states are pursuing these laws, but under the Voting Rights Act as it currently exists, can you explain why these laws are so difficult to successfully challenge in court?
Thank you, Senator Coons. As I said at the outset, litigation is one of the tools that we have available, and we, by the way, have challenged SB 202 under the Constitution. We challenged it under the First Amendment, under the 14th Amendment, under the 15th Amendment, and under the Voting Rights Act. But litigation it takes a long time. It is expensive. It can take from 2 to 5 years. I'll give you an example. LDF was part of the team that successfully challenged Texas's voter ID law between 2014 and 2018. But during the pendency of that litigation, there were 500 offices that were elected in Texas, justices of the Texas Supreme Court, attorney generals, district attorneys, lower court judges, county council persons, elections that proceeded despite the fact that we had demonstrated in our litigation that 600,000 Texans were likely disenfranchised by that particular voter ID law. So litigation is a blunt instrument. What preclearance gave us was the opportunity to get out ahead of voting discrimination before it happened, to have a review of the kind that should have happened with SB 202, which is one of the features that hasn't been talked about. The way this law was rushed through, we were there. Bills were dropping at 11 p.m. and then hearings were held on them the next day at 7 a.m. As we tried to keep up with this process. This sweeping bill, this omnibus bill, was passed in this fashion that didn't even give a real opportunity for study. Where is the racial impact study on these provisions and how they will affect Black voters in the state? You won't find it because it wasn't done. A preclearance provision would have allowed a neutral authority, a federal authority, to look at every single proposed voting change and to determine the effect on Black voters. And that would then answer Senator Cornyn's question about what was the motivation, what is the effect of the laws. But we didn't do that because we don't have preclearance and because Georgia was hell-bent on pushing this law through as quickly as possible. And so now we're left with litigation.
Well, thank you, Ms. Eiffel. Ms. Abrams, good to see you again. How would having the John Lewis Voting Rights Advancement Act in place operate on other similar laws in the future? And given the point you made earlier about the timing and the intent and the context of voting legislation is critical, how would preclearance analysis have impacted the enactment of Senate Bill 202?
Senator Coons, you frame it properly. What preclearance does is look not simply at the piece of paper before you in the form of the law, but look at the context, look at the history, and look at the effect. Those have to be taken in totem because Georgia has a different history than, let's say, Texas or New Hampshire. And in each state, one would have to look at what has happened when these things occurred, not in the macro, but in the very micro sense of what happened in the places where these laws are taking effect. For example, in the state of Georgia, the closure of polling places, 214 that closed by 2018, led to between 54,000 and 85,000 voters not being able to cast their ballots because they could not get to their polling place. This is not incidental. This is the difference in elections. We also know that the requirement of providing ID for 200,000 voters who have not been required to physically send in their identification will change how they can participate in our elections. And despite the misnomer of free ID, there's nothing free about identification when you have to pay for the paperwork to comply with the identification.
Ms. Abrams, if I might ask you a quick closing question. One provision in SB 202 surprised me or concerned me. It strips authority over election administration from the Secretary of State and transfers it to the state legislature. Given the context of the 2020 election, how will this transfer of power affect the partisanship of future election administration, and how would you read it, given the recent history in Georgia?
This is a very, very offensive language that not only removes home rule, it actually will put into power people who have nothing to do with communities. And for a body that seems to believe that those who are closest to the people should be making the decisions, giving these, number one, giving state legislatures the authority on their own motion to remove officials, elections officials, is dangerous. If that had been in place in 2020, the outcome of the 2020 election could have been vastly different. And we should be deeply concerned by the aggressive and naked attempt to wrest control away for purely partisan purposes.
Thank you, Ms. Abrams. Thank you for what you and Fair Fight Action are doing. Thank you, Ms. Eiffel, and thank you to everyone who's participating in today's hearing. Thank you, Mr. Chairman.
Senator Lee?
Thank you, Mr. Chairman. I'm disappointed